What is the manner of voting? Voting by show of hands. Normally, voting is through show of hands, right? That means one person, one vote. No matter what is your voting power. See, if I have 90 shares of the company, you have 10 share also, then also certain matter says the voting will be by show of hands. My is also one hand, your is also one hand. One member, one vote, irrespective of the voting right. One member, one vote, irrespective of their share capital, shares held by them. So voting by show of hand means one member, one vote. But if the certain members are not happy, satisfied with the decision of voting of show of hands, they may demand for poll under 109. Here, one share will have one vote. One share of one vote means if you have one share, you have one vote. I have 10 shares, I have 10 votes. That means the voting power according to the share capital. Who may demand for the vote for poll? Those members having 10% of the voting power or at least value shares 5 lakh rupees. If a member having 10% of the voting power or if a member having 5 lakh rupees share capital, if he requires after the show of hands, even after the show of hands, if he is not satisfied and he is such a big shareholder, then he may demand that the voting will be made according to the share capital and not one person, one vote. Under 109, the polling will be one share, one vote. Simple. One share, one vote. Of course, there are certain other manners also for the listed company, electronic members. Electronic voting is also provided. Postal ballot under 110. This is an important topic. Matters to be discussed by postal ballot. So for that, we need to summarize all the matters one by one. Sorry, voting powers, voting manners basically. First is by show of hand. We had already discussed 107 has nothing much to discuss. One person, one vote. We will not be checking the share capital. Initially, if any matter is conducted, the first step of voting is by show of hands. If nobody objects of if nobody raises an objection to the show of hands, the matter will be conducted by show of hands only. Here, one person will have one vote, no matter whatsoever share capital you are having. If I object, and who is the authority to object? Those persons having at least 10% voting power or those persons having at least 5 lakh rupees shares. They can object that no, the voting will not be by show of hands, it will be by poll. Poll means every share will have one vote. If you have one share, you have one vote. I have 10 shares, I will have 10 votes. Voting according to the share capital. Simple. Now, demand for poll. This is important. 109. Before the declaration of the result of show of hand, the poll may be ordered by the chairperson or on its own motion, or if the poll is demanded by at least 1/10 of the shareholders or the shareholders having at least 5 lakh rupees paid up capital. Then the poll, if the poll is demanded, then the poll will be taken. The poll may be on the matter of the chairman appointment. You are not liking the chairman himself. We need to have a poll that whether the chairman will be, this particular chairman will continue in the meeting, or we need to have the chairman, any other chairman of the meeting. So for the meeting chairman decision, the poll will be taken forthwith on the spot. For any other meeting, it is not compulsory to be taken for the poll to be taken on the spot. 48 hours can be given to the shareholders and they can submit their decisions either electronically or through post or through anything. They can communicate their decision in writing within 48 hours. Simple. So this point is very important. The poll may be taken at any point of time, but for the appointment of chairman, it will be taken forthwith. And for any other matter, it will be taken within 48 hours, either in writing. They can go home. The meeting is concluded. For this particular matter, you go home, you think about it, and you send us your email within 48 hours. And the voting will be done according to your share capital, your voting power held by you. This is how the demand for poll is conducted. Next point is postal ballot. See, sometimes it has been seen. See, in the previous example also, just see this previous example. I am copying this particular example. Just see the chat box. Your company has 2,000 members. Only 100 members came. Apart from it, 50 members voted, 30 didn't voted, or whatever. Right? But out of 2,000, only 100 members came to your company to conduct voting. What about the 1,900 members? They are least bothered. And even in greatest of the greatest company, this happens. The members don't go to the company for the meetings. They are least bothered about anything except dividend. They are just concerned about their dividend. So postal ballot is to ensure maximum participation of the shareholders. If you are not willing to come, send your answer through post. At least if 100 member came and voted, at least 200, 300, 400 more people should have sent their post, their decision through post. So what is postal ballot? For a particular important matters. What are the matters we will be discussing in the next slide? The lawmaker says, when you are sending the notice of the meeting to the shareholders, attach with the notice a letter in which the business to be transacted has been defined, and just ask them to either say yes or no, tick either yes or no, and send their postal ballots to the company again through post before the general meeting. In the general meeting, we will open those postal ballots, those documents. In this particular example, see, 100 member came. If we assume all 100 had voted, what about the 1,900? Out of 1,900, we will see 500, 600 postal ballots also there. We will open each and every postal ballot and we will count yes or no then and there in the general meeting. Because the shareholders, even if they are not willing to come to the company or the place of meeting, they had sent their decision. How it is any botheration to you if I come and give you a decision, or if I give my decision through post? Consider my vote. So postal ballot is to ensure maximum participation and in the decision making by the shareholders. And what are the matters which needs to be mandatorily conducted through postal ballot? Just see, 10 points are defined under section 110, in which if the company is giving the notice that in the general meeting we are going to discuss these 10 points, then the postal ballot will be attached in the notice. You separate the notice and the postal ballot, you see the matters and you just say yes or no and send it again. The company will themselves send a prepaid envelope, postage envelope. You just tear the page, mark yes and no, and just submit to your post office. Address of the company and everything is written over there. Right? Now, what are the matters? We need to learn all the matters. If you are changing the object clause of the memorandum, you are changing the entire business for which you have raised the funds. Right? If you are changing the articles, that you are either converting your private company to the public company, or you are converting a public company into a private company. This is a very important thing. Postal ballot is required. If you are changing your office itself beyond the city, right, beyond the district, you need to have the postal ballot. If you are changing the objects which you have defined in the prospectus, what is prospectus? You have came up with the IPO, FPO, you had raised the funds, now you are changing your object, which was not mentioned in the prospectus. This is not allowed. Take the permission through postal ballot. If you are issuing the shares with differential voting rights, this is an altogether separate story. If you are varying the rights of a class of shares, if you are proposing the buyback of shares, the company is buying back the shares from the public. If you are electing a director under 151, that is small shareholders director. If you are selling the undertaking, you are selling the entire business, or you are selling the undertaking. Say, for example, your major manufacturing factory, you are selling the major plant in which on upon which the your business is dependent, right? Or you are giving the loans, or providing guarantee, or providing security to other corporates in excess of the limits under 186. 186 deals with the loans and guarantees or intercorporate loans and advances. That means one company can give the loan or give advance or give guarantee in respect of any loan to any other company. Up to a limit, it is allowed. The board of directors may decide and give loan or guarantee or invest in the shares of other companies. But above a limit, we as a shareholder had given you the fund for business, and you are just investing the funds outside the business. So above, over and above the limit, the matters to be passed as ordinary resolution, even by postal ballot. That is required. So these 9 matters, if your company is considering, you need to ensure maximum participation through postal ballot. Attaching the postal ballot to your notice to all the shareholders is mandatory if in the upcoming general meeting you are deciding such kind of matters. This is important. Simple. Now the last things last. The last slide is section 118, meetings of the minutes of the meeting. Minutes means the documentary evidence, the documentary record in which it is written what things were actually discussed, how many votes were casted in favor or against of each and every matter, what exactly was the result of the meeting. And this is an evidence in the law. How can we assume that, how can we believe that you conducted a general meeting? How can we assume that, how can we believe that you had casted a vote in favor or against of any motion? The documentary evidence is minutes. Every company shall prepare the minutes of each and every general meeting, class meeting, even board meeting. Okay. Every resolution passed by postal ballot, every board meeting, every committee meeting, and within 30 days from the conclusion of meeting, you need to prepare and sign the minutes. The minutes shall contain the fair and true summary of the proceedings. What exactly happened in the meeting, you need to disclose it in the minutes. All the appointments made at the meeting, whether of auditors, whether of directors, KMPs, you need to mention in the minutes to take that appointments in effect. Say, for example, you voted in favor of a person to make him a director. That particular thing is missing in the minutes. We will not allow him to to be the director. If you really want to actually execute a decision, you need to incorporate in the minutes. The minutes are actually the proof that this particular resolution has been passed, this particular matter has been made. Right? In the minutes, you shall also mention who all directors were present, right? Who all directors voted at the meeting, voted in favor, voted in against, especially in board meetings as well. Right? Because 118 deals with general meeting also, and 118 deals with board meeting also. Right? And if the chairman is of the opinion that some matter is defamatory, it is irrelevant, immaterial, detrimental to the interest of the company, such particular matter can be excluded from the minutes. Rest all, each and every proceeding will be recorded in the minutes, and it will be the prima facie evidence in the court of law. Mind my words, minutes are prima facie evidence, not conclusive evidence. You know better than me what is prima facie evidence and what is conclusive evidence. Law of evidence. Right? So the chairman, we had already discussed, the chairman has absolute discretion what will be included and what will not be included in the minutes. The minutes will be evidence. And I had already told you, it has been clarified that the minutes are prima facie evidence. Yeah, that means, can someone challenge the minutes? The answer is yes. You can challenge it otherwise. So where the minutes have been kept, see, then until the contrary is proved, that means the contrary can be proved. That means minutes can be taken as a prima facie evidence, not as a conclusive. We can challenge it. So if unless the contrary is proved, the meeting will be deemed to be called, held, all the proceedings have been made, all the directors appointment, KMP appointment, PCS appointment will be made as valid. Whatsoever is written in the minutes will be held as valid unless the contrary is proved, which makes the minutes as prima facie evidence in the court of law. Simple. No document purporting to be the report of the proceedings shall be circulated. Means the report of the meeting, the minutes of the meeting, any summary of the meeting, no document shall be circulated at the expense of the company, unless it includes the matters required in this section, which is not that much important provision. Subsection 10, 118 subsection 10 is very important. Like the Company Secretaries Institute had issued secretarial standards, SS1, SS2. SS1 deals with board meeting, SS2 deals with general meeting, SS3, SS4, and so on. So every company shall observe SS in respect to general meeting and board meeting, which is issued by the ICSI. There are n number of points of how to conduct a board meeting, how to conduct a general meeting as per SS1, SS2 issued by the ICSI. You need to observe such secretarial standards as well. If you had made any of the default under this section, the company is liable for a penalty of 25,000 and officer for a penalty of 5,000. Second thing is, if you are found guilty of tampering with the minutes, if you had tried to conduct a fraud through minutes, if you had tried to omit some fact from the minutes, if you had tried to add on some irrelevant facts or false facts in the minutes, you will be held as guilty of fraud. Tampering with minutes is known as fraud. And fraud means jail up to 2 years, fine up to from 25,000 to 1 lakh. Where we had used the word fine and imprisonment, you will be facing the court, NCLT. See, what is the difference between 11 and 12? 11 is the normal penalty which is imposed by the ROC, right? You had not observed SS or you had not made the minutes properly or whatever. But if you have been found guilty with the tampering means chhedi kari aapne, then this is a court case. You will have to appear before NCLT as a criminal. So this is a criminal offense, right? So last thing is about minutes is section 119. For whom the minutes have been made? For the members, for the directors. Can the members inspect the minutes? Yes. So 119 states that the proceedings of the minutes shall be kept at registered office. First of all, you make the minutes within 30 days of the meeting. Get it signed from the chairman and place it in the registered office. And you need to kept it at the registered office, and you will make it available during business hours. We know that business hours is 9 to 6. We had already discussed in the point of AGM. For the inspection by any member without charge, no fees will be charged for inspection. Another important thing. Subject to certain reasonable restrictions. What are the restrictions? That ऐसा तो नहीं हो सकता कि कोई भी मेंबर कभी 9 बजे आ रहा है, कोई 7 बजे आ रहा है, कोई 5 बजे आ रहा है, वो नहीं कर सकते. रेस्ट्रिक्शन क्या हो सकती है कि आपको अगर इंस्पेक्ट करने आप 2 घंटे के लिए आ जाए, 3 घंटे के लिए आ जाए, 1 to 4 आ जाए, between 1 PM and 4 PM. But in that case also, the company can restrict the inspection hours, but at least 2 hours will be given. You can't say दिन में ये 3 से 3.5 के आधे घंटे में ही आओ. No, at least 2 hours will be given. Restrictions can be applied, but not less than 2 hours will be given for the members for inspection. Simple. Now, If a member needs to inspect then and there, that is free of cost. But if any member says that I need a copy of the minutes, then he can inspect then and there. And if he say that give me a copy, supply me with the copy of minutes, then the company will within 7 working days after his request shall give him a copy at his office, of course subject to payment of fees. Fees can be charged, and within 7 days the entire copy of the minutes will be sent to the member at his home. Simple. Now, if the inspection, if I as a member came to your company for inspecting the minutes, and if you have refused, or if I've asked you to send me the copy of minutes and you had not sent me the copy within 7 days, then the company is liable for a penalty of 25,000 and every officer 5,000 rupees. And what about me? I wanted to inspect, then the NCLT without prejudice order the immediate inspection. So what you will face, I will complain against you in NCLT. NCLT will pass an order imposing some fine and penalties upon you, and I will be given the forthwith inspection of the minutes. This is 119.